Hello everyone, welcome back to Legally Dephine. This is part B of our lecture on the lawmaking process in Zimbabwe. In part A, we explored the state organs and their powers. Now, let's dive into how laws are actually made in parliament. Don't forget to subscribe. The Constitution of Zimbabwe specifies the manner in which parliament legislates. Section 131 of the Constitution provides that Parliament's legislative authority is exercised through the enactment of Acts of Parliament. Section 131 subsection 2 of the Constitution defines an Act of Parliament as a bill which has been presented in and passed by both houses of the Parliament and assented to and signed by the President in accordance with this Constitution. This means that Parliament can only make law through the passing of bills. The procedure to be followed by the Senate and the National Assembly with regard to bills is set out in the 5th schedule of the Constitution. The Constitution also empowers the Parliament to make what are called standing orders, which prescribe the passing of bills. Accordingly, the two sources to which reference must be made with regard to passing of bills are the 5th schedule of the Constitution of Zimbabwe and the Standing Orders of Parliament. The Standing Orders of the Parliament constitute a specialized form of legislation approved by the Constitution. If Parliament attempts to pass bills contrary to the procedure set out in the Standing Orders, the resultant act is invalid and of no force or effect. Before a bill reaches Parliament for scrutiny and debate, it must originate from a source or individual. Public bills undergo numerous proceedings before they are presented to Parliament. The Prebill Stage represents the initial stage of the lawmaking process, leading to the finalization of the proposals contained in the bill sent to Parliament for scrutiny and debate. In Zimbabwe, this process is predominantly a political one, heavily dominated by the executive through the cabinet. Public bills may originate from various sources, which include but are not limited to political party manifestos, government departments, commissions of inquiry, parliamentary portfolio committees, responses to natural disasters, and so on. A significant issue is the extent to which the government is obligated to consult interested parties before presenting a bill in Parliament. Under Zimbabwean law, there is no legal obligation for the government to consult, much less be bound by the views of any person before presenting a bill to Parliament. Consultations are conducted at the government's discretion. Therefore, in Zimbabwe, legislation is initiated by the executive. The process by which law proposals become effective law is mostly done in clandestine procedures. This means that it is done in secrecy, but it appears to follow the following steps. Firstly, the cabinet makes a policy decision that a certain law is to be made, for example, making it mandatory for all motorists to purchase a radio license. This decision is then communicated to the relevant government departments by the appropriate ministers. The department must then prepare a set of detailed principles to govern the legislation. Number 3. These principles are sent to the Cabinet Committee on Legislation, a subcommittee of the Cabinet tasked with overseeing legislative drafting. Its function is to debate and approve the principles in light of the policy outlined by the Cabinet. From the Cabinet Committee on Legislation, the principles are then sent to the Attorney General's office, where a draft person is appointed and assigned with the task of drafting the legislation. The draft person must work in constant consultation with the relevant government department. Once the department is satisfied with the draft, it sends a draft bill along with an accompanying memorandum to the Cabinet Committee on Legislation, which must scrutinize it in light of the principles and the policy made by the Cabinet. After approval by the Cabinet Committee on Legislation, the bill may be sent to the full Cabinet in case of important or controversial bills, or to Parliament if the Cabinet Committee on Legislation has been approved to do so. A distinction must be drawn between public and private bills. Public bills are those that are intended to alter the general law or to deal with public revenue or the administration of justice. Private bills deal with matters of a private or local nature, such as legislation promoted by local authorities or relating to the property of private individuals. Within the class of public bills, a further distinction is drawn between a government bill, which is introduced by a government minister, and a private member's bill, which is introduced by an individual member of parliament. The Government Gazette is the official publication of the government of Zimbabwe. It is the legal medium through which the government informs the public about its legal instruments. Except for the constitutional bill, the Constitution does not require that bills be gazetted before they are introduced in Parliament. A constitutional bill is one that seeks to amend or repeal any provision of the Constitution. The text of such a bill must be published in the Government Gazette not less than 30 days before it is introduced in Parliament. For all other bills, the standing orders require that they be published at least 14 days before they are introduced in Parliament. This requirement, however, may be waived in cases of emergency upon application by a Vice President or a Minister. As Parliament has two houses, a bill must be introduced in both houses and passed by both houses to become law. The same stages are followed by each house. In general, the process in one house must be completed before the bill is introduced in the second house, except for a type of a bill called a money bill, which may only originate from the National Assembly. A bill may originate from either of the houses. A money bill is defined in Section 1 of Schedule 5 of the Constitution as follows. In this schedule, money bill means a bill that makes provision for imposing, increasing, or reducing a tax for the benefit of the state, appropriating money from, or imposing, increasing, or reducing any charge on the Consolidated Revenue Fund or any other fund vested in or controlled by the government, compounding or remitting a debt due to the state, condoning a failure to collect a tax due to the state, or condoning unauthorized expenditure by the government. After a bill has been gazetted, the member responsible must serve a notice of motion that leave be granted by the House to bring in the bill. On the day specified in the notice, the motion for leave is moved, and if granted, the member must bring in the copy of the bill to the clerk's table, who then reads the title. It is the bringing of the copy to the clerk's table and the subsequent reading of the title that is regarded as the first reading. The bill is then referred to the Parliamentary Legal Committee as per the Constitution and the standing orders. This committee is set up in terms of Section 152 of the Constitution, and its purpose is to examine all bills and statutory instruments and determine whether they are in conformity with the Declaration of Rights and any provisions of the Constitution. If the Parliamentary Legal Committee makes an adverse report, that is to say, if it finds that the bill contravenes any part of the Declaration of Rights or the Constitution, it is sent to the National Assembly or the Senate as the case may be. In terms of Schedule 5 of the Constitution, if the Parliamentary Legal Committee reports that a provision of the bill, if enacted, would contravene the Constitution, the House concerned must not pass the bill containing that provision. If the Parliamentary Legal Committee fails to present its report within the specified period in the standing orders, it shall be presumed that there is no adverse report and the House concerned may proceed with the bill as if the Parliamentary Legal Committee had reported as required. The second reading stage is initiated by the sponsoring minister, who delivers a speech outlining the purpose of the bill and the principles upon which it is based. This is followed by a debate on these principles. Discussion on individual clauses is not permitted. However, reference can be made to these clauses as part of the debate. Following recent reforms to Zimbabwe's parliamentary system, it is at this stage that the relevant Parliamentary Portfolio Committee will present its report on the bill. Parliamentary portfolio committees are appointed for every government department, and one of their functions is to scrutinize proposed bill, which includes conducting public hearings and presenting to Parliament. The entire House then forms a committee to consider the bill in detail clause by clause. The guiding principle is that the committee should make amendments to the bill that are likely to make it more acceptable. However, the committee must ensure that it does not amend the bill in such a way that conflicts with the bill's principles. The committee will also consider recommendations made by the relevant Parliamentary Portfolio Committee. This stage involves making a report of the bill as amended to the whole House. If the bill was considered by the whole House, this stage is a mere formality. If the bill was considered by a special committee, this stage allows other members of the House to propose amendments. Government may also use this stage to reverse amendments made at the committee stage or add new clauses arising from any subsequent deliberations. If the bill is amended at the committee or reporting stages, it is sent to the Parliamentary Legal Committee, which will scrutinize any amendments according to the procedures outlined in Stage 2. This is the stage at which the bill is put to a vote for either approval or rejection. No actual reading takes place at this stage, and there is no debate unless some members have given a notice that they wish to do so. Once the bill has been passed in the House in which it originated, an authenticated copy of it is transmitted to the other House. If the second House passes the bill with amendments, it returns the bill to the House of origin. When the bill is transmitted in the manner outlined, disagreements may occur between the two houses. If the second House passes the bill with amendments, it returns the bill to the House of origin. When the bill is transferred in the manner outlined, disagreements may occur between the houses. The disagreements between the two houses are dealt with as provided for in Part 2 of Schedule 5 of the Constitution. However, importance is given to the National Assembly if the Senate and the National Assembly have not agreed on amendments to be made to a bill which originated in the National Assembly within 90 days after the bill was introduced into the Senate. The Senate and the National Assembly have not agreed on amendments to be made to a bill which originated in the Senate within 90 days after the bill was returned to the Senate, or a bill which originated in the National Assembly has been rejected or has not been passed by the Senate within 90 days after the bill was introduced into the Senate. The bill may be presented to the President for assent and signature in the form in which it was passed by the National Assembly, except for minor changes required by the passage of time and any amendments on which the Senate and the National Assembly may have agreed. When a bill has been duly passed in accordance with the provisions of the Constitution and the requirements of the standing orders and signed by the Clerk of Parliament, it is then presented to the Head of State for assent within 21 days as per the Constitution. The President grants his assent by authenticating a fair copy of the Act with his signature and attaching the public seal. If the President withholds his signature, he must send the bill back to Parliament with a list of concerns to be addressed. Therefore, a bill only becomes law after being assented to by the President. What is the effect of Parliament's failure to follow specified procedures? If Parliament attempts to pass a bill contrary to the procedures we have examined, the law is that the resultant act is invalid and courts are empowered to intervene and declare the law of no force or effect. In this case, the applicants challenged the General Laws Amendment Act 2002 and sought to have it declared illegal and of no force or effect as it had introduced far-reaching and controversial changes to the Electoral Act ahead of the 2002 presidential election. Make sure to read this case, it's a very interesting read. Parliament may delegate its lawmaking powers to a variety of public authorities, particularly the President, ministers, and local authorities. Legislation emanating from these authorities in exercise of the powers granted to them by Parliament is called Delegated Legislation. The extent of the power to make law in this way is regulated in each case by the relevant Act of Parliament, the Enabling Act or Parent Act. Section 134 of the Constitution of Zimbabwe allows Parliament to delegate its lawmaking powers. However, delegated legislation, like any other legislation, must be consistent with the Constitution, that is, it must be intravenous with the Constitution, and it must be consistent with the Parent Act or the Enabling Act. And that's how laws are made in Zimbabwe. I know there are a lot of offices in this video, who does what, which goes where, but trust me, you'll get it as time moves on. Thank you for watching part B and check out part A if you missed it. Don't forget to like, subscribe and share your comments in the comment section.